We'll get started. So thank you, everyone. I have got my voice back this week. So thanks again to Helen for holding the fort last week when I was a little bit under the weather. But yes, unfortunate for you all, I just returned. So welcome to another Connect and Share. And we're beyond the 100 now. So this is our 100th and first Connect and Share that we're bringing to you from Outdoors New South Wales and ACT. So we've got an amazing lineup for you this morning, but before we kick off and get started, I want to acknowledge the traditional owners of the land in which we all meet today. I come to you from Darug country in northwest Sydney and pay my respects to Aboriginal traditional owners of the land, past, present and emerging leaders we want to work with to do more in understanding our country. So let's jump into today, and it is around a significant case that just went to the High Court. I can't do the talk of all the things around this case, so I have brought someone to you to help do that. And thank you so much, Ross, for being here today, and thanks to Mary from Aon for connecting us to you and bringing this information so important for our industry to us. So I'm going to hand over to yourself and we'll kick off, and at the end of the session I've got a few reminders for our industry to get everyone up to speed on what's going on around the traps. But let's start with yourself, Ross. So thank you again, and I'll hand over to yourself.
Thanks very much, Laurie. Thank you for the opportunity to talk today. Laurie's asked me to talk about TAPP and the Australian Bushmen's and Camp Draft Radio Association recent High Court decision in April of this year, and I'll talk generally about some other cases and some general principles about recreation liability, and with a view to sort of teasing out some of the issues that were raised in TAPP. I'm principally a litigation lawyer in Melbourne. I principally act for insurers, so we are instructed by insurers when people get sued, when they have liability insurance or professional liability cover. I do a lot of work for professionals in that space, and I've also had a sort of practice in recreation liability over the years. So I've acted for a lot of recreation providers, camps, schools, that sort of thing. And also, I've done a lot in the horse riding space, in the trail rides and teaching, counselling sort of space for horses. Not in the competition area in the sense of professional competition like horse riding, but in the amateur and recreational level. Just starting with the background to TAPP. TAPP is about an injury sustained while undertaking the competition of camp drafting. It's a recreation injury. In a camp draft competition, the horse and rider are working cattle, and they attempt to separate and cut out the animals from a herd in an arena. They must drive the animal around 2 pegs on a figure-of-8 course to show the rider's control of the animal, then drive the animal through a gate to complete the event. They're judged on their horsemanship and control, and they have to complete the task within a set time frame, around 45 to 47 seconds. So the horse is generally ridden at quite high speed, and they are manoeuvred tightly around a relatively short course. TAPP and her father were experienced camp drafters. The evidence was that TAPP had commenced camp drafting at the age of 6. She'd been in competitions and she had won awards. The event that was the subject of this accident was one of these competitions held over a number of days. It was held over 2 days, a Friday and a Saturday, and there were some 700 riders or rides that had already occurred on the arena before TAPP's fall. Her fall occurred on the second day, the Saturday, on the second day of the competition. Her account and others who witnessed the accident were that the front legs of her horse appeared to slide from under it, and it fell to and it fell forward, and she fell off the horse, and she sustained a serious spinal injury, which, if she recovered against the association, would sound in a claim for substantial damages. Her complaint was that the association should not have allowed her event to proceed. She said the ground had become slippery and unsafe, and she said the horse fell because of the ground condition. She was not aware that the condition of the ground had deteriorated before her race. In response, essentially the association's defence was the horse simply slipped or fell, a common risk of horse riding generally, and had nothing to do with the surface of the arena. Essentially, they said no one could know how or why the horse had fallen. It was general practical knowledge and within the association's rules that the arena and the surfaces had to be well maintained, and they had to be ploughed regularly for the purpose of all competition events. The case is interesting for a number of reasons. First, it involves a claim for damages for injury arising out of quite a dangerous recreational activity, an activity that the participants clearly knew was dangerous and was fraught with risk of, you'd have to say, injury or death. Secondly, it went all the way to the High Court. It went to trial in New South Wales. It went to the New South Wales Court of Appeal, and then it ended up in the High Court. The High Court saw the application of the legal principles applied in the lower courts to be incorrect. And third reason is, of course, because it's a High Court decision, it's binding on all courts below it. So it's significant in that regard. But when you strip it down, it is a simple negligence claim. Most outdoor recreation claims are made in negligence. Sometimes an additional claim is in breach of contract and misleading and deceptive conduct, but all of them will be first in negligence, or most of them will be. And the basic ingredients of a negligence claim are the following: that the association owes a duty of care. You have to establish the association owes a duty of care to a participant to avoid foreseeable harm to them. Secondly, that the association failed to breach that duty of care. And thirdly, that breach that is proven caused the injury. And in all negligence cases, the plaintiff has the burden of proof to prove all these elements of the claim. In this case, in TAPP, she only had to prove the second and third components, that is, that there was a breach of the duty and that breach caused the injury. The idea that the association owed her a duty of care was not disputed, and indeed any association organisations that's running events of this kind would, as a matter of law, owe a duty of care to participants. Just some additional facts about the claim. I'm only paraphrasing. There's quite detailed facts in the judgments, and I'm just only covering some basic key points that might be relevant to our discussion. Naturally, the association undertook hazard and risk assessments of the arena, including the ground conditions before each event. The arena was ploughed, it was inspected. On the day of the accident, the ground had been slightly wet from rain, but others helping to manage the arena and the event said it was safe when they competed. TAPP and her father competed the morning of the accident without incident, but 5 other riders had had falls that day. One of them rated as hard, meaning prospect of significant injury. But none of the riders that had fallen expressed a concern that it was caused by the surface of the arena. TAPP said in her evidence that she was unaware of these earlier falls that day. But during the course of the competition on the second day, on the Saturday, there were a number of complaints about the condition of the ground and the arena. I think it was a Mr. Stanton who approached officials and said he was concerned about the state of the surface, essentially that it was becoming chewed up and uneven and was posing a risk to riders. He approached the officials twice and they stopped the event twice, and some officials inspected the ground. They concluded that it was still safe to ride, so the event would continue. But they decided that they would give a sort of warning to the participants going forward that they should ride to the conditions, which I understand to mean be aware of the prevailing conditions. Perhaps the conditions had changed, so be aware of those conditions and ride accordingly. And that those riders who didn't want to participate, who thought that they were at risk or were uncomfortable with the situation, would get a full refund. Now, the evidence is that they made some announcements over the loudspeakers about that. But TAPP's evidence was that she did not hear these announcements as to the ride to conditions and as to the refund, because she was busy outside the arena preparing for her event. The trial judge accepted her evidence on that point. It's also interesting to note that her father had given her his slot to compete in the open event, and he'd also given her his horse. So as I understand, she wasn't riding her normal horse, but the significance of that didn't appear to play out in this case. So when it went to trial in New South Wales, it was heard before a single judge, and the judge hears all the evidence, all the witnesses to the accident, the expert evidence. And in order to determine whether the association had acted reasonably, a court must first determine the risk of harm that the association must protect riders from. In simple terms, defining the risk forms a template to assess the conduct of a party like the association. So in this case, the trial judge said that the risk the association must protect TAPP from was the risk of harm of falling off the horse while competing in a camp draft competition. It's a fairly broad description of the risk, essentially the risk of falling off a horse while competing in this competition. So to assess what the association had done in that context, the trial judge found that the association had informed itself about the conditions of the surface of the arena and had considered whether the competition should continue. They had made a reasonable assessment. They permitted the competition to continue, and therefore they had not breached any duty they owed to TAPP. And that their decision to allow the competition to continue was reasonable because they had inspected the ground, made their own assessments based on their experience. There was also raised what's called a defence of obvious risk. If you can establish in some states that the accident arose out of an obvious risk of a dangerous recreational activity, it's a complete defence to a negligence claim. So in this case, I must say that in Victoria that we don't have that provision, but in New South Wales and I think Queensland and other states do. In this case, there was a known risk of falling off a horse, particularly when you're driving a horse in the way they do in camp drafting. So any rider, including TAPP, would concede they knew that there was an obvious risk of injury or death from this activity. But in this case, the trial judge found that the accident arose out of the materialisation of an obvious risk, something known to TAPP, and therefore there's a complete defence to the claim. So both on the evidence, the trial judge found there was no negligence, but even if there was, because it had arisen out of an obvious risk known to TAPP, she would not have been able to succeed. So she failed entirely at first instance. It's interesting to note that TAPP called 2 experts to give evidence about the surface of the ground, but that evidence was rejected by the trial judge. And it's probably because their evidence was probably more speculative than anything else, because they weren't there at the event and probably inspected the ground considerable time after the event, and the evidence, their expert evidence, wasn't persuasive enough. So then Ms. TAPP appeals to the New South Wales Court of Appeal. In the Court of Appeal, there's 3 judges hearing the matter. They found there was no breach of any duty, and even if there had been a breach of duty, that breach had not caused the fall. Significantly, they found that TAPP had not proved the cause of the horse falling or slipping. She had not led sufficient evidence to suggest it was the surface, which the association was responsible for, had caused the fall, or that there was a deterioration in the surface. The court noted that falls in events of this kind were commonplace due to the speed and manoeuvring of the horse. The court also determined that evidence of other falls and the fact that the association stopped the competition to inspect was not enough to suggest the surface was poor or that the surface had caused the fall. In concluding, they found that why the horse fell was not ever established to their satisfaction. The court held that the association's obligation was simply to make an informed decision about the surface and whether it was safe to continue the competition. It should be noted that was 2 judges against 1 decision. One judge disagreed and thought TAPP's case was strong, but he was in the minority. Then we go on to the High Court, and the High Court ruling was held in April this year, so 11 years after the accident. The High Court found in favour of TAPP, so entirely reversed the decisions of the Court of Appeal. And it was a 3-2 judgment, 3 judges against 2 judges. So they went back first to the question of assessing the risk. What is the risk the association must protect participants from? In this case, they found that the trial judge had defined the risk too broadly, and they suggested the risk should be defined more specifically, and that is the risk of injury from falling from a horse that slipped by reason of the deterioration of the surface, not simply a risk of falling while undertaking the activity. And they said that when this risk is looked at, the association had not taken sufficient care. When you apply, as they did, the criteria set out in the Civil Liability Act, which requires a court to consider whether the risk is not insignificant and whether the burden of taking steps to protect participants from harm is low, then they considered that there was sufficient evidence to show there was an elevated risk due to the falls and due to the complaints, and the association should have stopped the event. They found that a reasonable person in the association's position would have taken steps to stop the competition, particularly because the falls and the complaints, the court found that there was a risk substantially elevated. The risk of injury was very high. Risk of serious injury was very high. On the evidence, the High Court found also that the committee did not stop to, the whole committee did not stop to inspect the ground, the arena, and there appeared to be a desire to push the competition along to get it completed so people were not disadvantaged, those who had already competed in regard to their gradings and such. And finally, in regard to the obvious risk defence, they also reversed the decision of the trial judge. The risk was not obvious to TAPP because TAPP did not know about the deterioration in the surface of the ground before she competed. She wasn't aware of the other falls that morning, and she wasn't aware of the specific warning others had been given about the surface and the need to ride to the conditions. So she wasn't on notice about the risks, if there were some. The case, so essentially TAPP succeeded after 11 years and 3 court hearings. She achieved a substantial award of damages following the High Court decision. The case didn't involve waivers or disclaimers, contractual agreements, anything like that. There was no issues about that. I think from my point of view, my observations about the case is that it was the application of well-established negligence principles. It didn't create any new law, but it was a reflection of how one court can look at the facts and apply different tests to obtain a different outcome. The High Court had found the lower courts had applied the wrong test in regard to defining the risk, and that made a substantial difference to the assessment of the case. All the courts where this proceeding went through acknowledged that this activity was known to have high risks. But in this case, the High Court found that the risks were elevated and increased. But in many cases we deal with, and in circumstances you probably deal with, there are not elevated or high risk. So earlier decisions have grappled with how the risk should be identified for the purpose of assessing any breach of duty. A narrowly defined risk might be unfair to a plaintiff. If a risk is defined as pedestrians tripping on a footpath edge that is higher than 5 millimetres, when the edge that caused the fall is 4.5 millimetres, the plaintiff would be precluded from recovering. But a broadly defined risk might be unfair to a defendant. If the risk of tripping on a footpath is simply at the risk of any raised edge, then defendants are going to be exposed to significant multiple claims. So in my experience, there's no perfect answer, and a court will continue to grapple with how to define the risk in unique circumstances. So many of you aren't involved in activities that involve a high risk of injury. Perhaps some are. In those circumstances, you really only must take steps that are reasonable based on your knowledge of the activity and your participants. You can't take steps to protect participants from risks you don't know about or cannot be reasonably expected to know. There were useful comments in the High Court regarding organisers of these types of events not having an obligation to protect participants from harm. Their duty is tailored to the activity. It's recognised there are risks involved, and it's also recognised that there must be some freedom for people to take those risks, and it must be their own choice. In my experience, these comments are echoed in earlier judgments. So the law has sought to recognise operators should not be liable for all the risks commonly associated with activities. If I look at another case, another high-risk case that might be of interest to you, and see the application of different principles. In that case, Marks versus Skydive Holdings, it was a decision of the Victorian Supreme Court. Again, it's another dangerous activity, skydiving, but a very different outcome. The case dealt with the application of the principles of inherent risk, negligence, and contractual waivers. Inherent risk is a risk that arises that cannot be avoided by the exercise of reasonable care. In most states, if you establish the accident arose out of an inherent risk, then the negligence claim fails. In this case, there was a novice tandem jump participant. This person had signed up for their first time jump with an experienced skydiver. They landed heavily and she suffered a spinal injury. She sued the association, or I'm sorry, she sued the company that was running the skydive organisation. The evidence heard was that the accident was caused by a downdraft caused suddenly, and it forced them down rapidly just before the ground. The evidence was, or accepted by the court, that the instructor had reacted appropriately to reduce the rate of descent to cause, reduce the rate of descent caused by the downdraft. So the finding of the court was there was no failure to exercise reasonable care to avoid foreseeable harm. The court said this was a random event. The turbulence was invisible. So this sort of thing cannot be avoided. The court found that this was a materialization of an inherent risk of the activity. It couldn't be prevented, and therefore the skydive company is not negligent. So in that case, the claimant failed. The case also deals with the enforcement of waivers that I won't discuss today, but it is a real dilemma in cases in regard to indemnities, contractual waivers and such. They are difficult to enforce, and there are many slip-ups that people make in regard to getting people to execute those waivers, and also to make sure that they're in an appropriate form. My overview about changes in recreational law generally is that since the civil liability reforms in the early 2000s, there's more protection for recreational providers, but it's not perfect, and sometimes it's difficult to enforce. There are defences like the obvious risk defence. There's defences like the inherent risk defence. There's the old defence of voluntary assumption of risk. There are principles now that reduce your obligation to give risk warnings in certain circumstances where a reasonable person would appreciate or know the risk involved in the activity. These sort of provisions and the court's interpretation of them all show that there's a strong recognition out there that people want to participate in dangerous and adventurous activities and will assume a certain level of risk, and they should not be entitled to hold organisers liable if they sustain injury as a result of that risk. But to gain protection, they have to, the risks have to be known to people, to a reasonable participant. If they get injured by something that they were not aware of, that the provider could have controlled or managed, then an obvious risk defence or inherent risk defence is not going to succeed. So if I give you a simple example of the way the obvious risk defence is applied, a footballer assumes a risk of injury. An amateur footballer assumes a risk of injury when they go out on the field. They accept the imperfections of the ground, their own physical limitations, and the imperfections of other players. An obvious risk is a football player injured, slipping on the ground, or colliding with another player. A non-obvious risk is when a football player twists his ankle on a hole created by a hidden sprinkler maintained by the owners of the ground, which he was not aware of. The hole was not obvious to him or to a reasonable football player. In that case, an owner of the ground has breached its duty to the player by failing to take reasonable care to protect players from falling down such a hole or twisting their ankle. A defence of obvious risk would not succeed. The obvious risk defence and voluntary assumption of risk defence go hand in hand. If a participant cannot reasonably know the risk, they cannot consent to it. So TAPP's a unique case, and its facts are complex, and the application of the laws of negligence in these circumstances were quite unique and complex. But what I can say is, drawn from my experience in defending cases, recreation cases, and all the decisions I've had to read to consider assessing a provider's liability, the following kind of points I would make in regard to the provision of recreational services and how to minimise the risk to you in regard to claims are as follows. The first point I'd say is understand the skills and experience of your participants and tailor your activities accordingly. Understand the environment the activities are to be conducted in and seek to minimise the risk posed by the environment. if you can, follow the industry or association guidelines, codes and standards as best as possible as to how to safely conduct the activity, the instructions you should give, the equipment you should use. It's not not necessarily always a complete defence that you followed the rules and guidelines, but it does help to explain what you've done and why, and to show that you've acted reasonably in the circumstances. While conducting the activity, regularly review the conditions and the participants look out for adverse changes in environment, the ability of participants, injury, fatigues. Don't be afraid to modify your event or your activity, or stop the activity completely. Next, if you can record your approach, your activity plan, your assessment, so you can show your thinking and explain your actions, that's useful for complaints and defending proceedings in the future. If you can get waivers and acknowledgements of risks from participants, that's a great thing. But if you wish to rely on the legal protections offered by waivers, acknowledgements, indemnities, make sure they're prepared by lawyers and make sure they're regularly reviewed and updated, because the laws change, principles change. Trouble with waivers, in my experience, is waivers and indemnities. They're often poorly drafted. They're often not updated. The law changes, but most of the time they're not drawn in accordance with the legal principles, and in many cases they're not enforceable. Yeah. And also making sure that people read the waiver and sign it and acknowledge it. There's a real issue in regard to people signing up for activities online and acknowledging a waiver online, and also, of course, with infants, kids under the age of 18, when their parents sign them up, or they sign themselves. And finally, the best advice I can give is to have good liability insurance and regularly review your liability insurance. Make sure that insurance covers the activities you are undertaking, and make sure it covers the entities that you're undertaking that activity within. Sometimes, for insurance purposes, we find that an insurer may resist covering you for a claim if it was an activity that they were not aware of, that it wasn't in your policy schedule or wasn't within the broad range of activities you say you were undertaking. And also, if you get the entity incorrect, you're running the business through some other company or something, and it's not on the policy schedule, you might have difficulties there. So those are the sort of things I think you should think about. So look, that's just my general view of some of the cases going around at the moment in respect to recreational liability. I'm certainly happy to answer any questions or queries if you like.
Amazing. Thank you so much, Ross. I think I've got heaps of questions, but I'd love to open it up because we've got some attendees today. This is very relevant for. Just a quick question on the good liability insurance. With this case, were they covered by their insurance for this 6.8 million payout? Do you know?
I don't know. I'm assuming they were. Yes, I do know. Actually, I should say I do know. I know, yes, they were insured, and it would be very unusual. Association of this kind would not have liability insurance. Yeah,
no, that's great. Dom.
Thanks, Laurie. Thanks, Ross. That was really interesting. I guess one question I have is, and you mentioned that the claimant, she wasn't specifically notified of the that warning about the change in the conditions and telling people to ride to the conditions and that they could get a refund. And I know this is probably conjecture, but do you think if before every rider came in, they repeated that warning to each person, that might have made a difference? Like, could that have, how they delivered that warning, was that actually crucial to the outcome?
I think it probably wasn't crucial. I think even if she'd heard that warning, I mean, the warning was just ride to the conditions, and it wasn't, the ground is slippery and dangerous, So my view is it probably wouldn't have made much difference. But I agree with you in delivering the information to a participant. They had to do it better than what they did, and perhaps going up to the rider before they go out into the arena would be the appropriate way of doing that. An official should have been there telling the rider, because clearly, from common knowledge, I guess, if you're outside the arena in the in the car park with your horse and cars and things like that, you're not going to hear much at all, are you?
Well, it also depends on the quality of those loudspeakers at a venue. You get the old waffle. No one knows what they say other than the person right there. And I guess the other part of that is, like, I guess coming in to generalize it a little bit more for outdoor activity providers, is it getting to the point of you need to be quite specific about what these non-obvious risks are, and if the provider's aware of it, then they need to at least, maybe it's, I've got an image of rock climbing behind me, to say, look, we've been told, by the land manager that there have been some rock falls here recently, and whereas you might think, well, there's no way you do this if there have been rock falls recently on this particular cliff. I don't know if that's a fair example, but if you go, well, that's why you're wearing a helmet, that's just in case a rock gets dislodged by someone up above you, is that the sort of specifics you think that operators need to move towards, like, rather than just saying, well, rock climbing comes with some risks, but we're all going to be safe today?
Yeah, I definitely. I think you need to be more specific, and it doesn't have to be too onerous. But when you set it out, you can say, and I've seen this in some disclaimers and such, saying, horse riding involves a risk of falling, serious injury, because the horse may get spooked, it may buck for no reason at all, it may do X, Y, and Z, and you can list a few points. And with rock climbing, I think you could say, there's a risk of rock fall, a risk of handholds breaking off, there's a risk of someone up above you knocking something off, those sorts of things. And then all the other risks of straining your muscles and fractures and things if you fall and things like that. But you can list that in sort of like a bullet point and try and cover the issue so that you're telling the participants what the risks are and you're covering yourself. The trouble with I think a lot of activities is that what the risks are because you've been doing it for a long time, but the average novice who starts just turns up because they want an experience like rock climbing. They'll probably have no idea, and they'll be able to say, I had no idea.
Awesome. Any other questions for Ross?
I was just going to make a comment in terms of what you're saying, and that difference between giving enough information and too much information so that the participants switch off.
Yeah.
Is probably the biggest challenge when you're participating in these sorts of activities. Or
it does tie into a sort of marketing kind of idea, isn't it? But how many people? It depends on who you're working with. If they're beginners, they just want a short experience, and I guess most people will just look at the form and sign off on it and say, yeah, I want to have a go at that. I would have thought disclaimers in the scuba diving area would be interesting. I haven't done anything in that area recently, but there's a lot of risks in scuba diving that they have to warn people of. Unexpected things, health things, so that, and I think they do list that in their disclaimers and warnings. Most good companies do.
Yeah. Just one other question, and it's probably something, well, I know it's something Helen knows quite well. What about the risk of trauma or mental health injury from if you observe, is that something you think actually should be put out there as, like if you saw someone, if I'm on a group rock climbing, I shouldn't pick on rock climbing, a group activity of any type, and there's a serious incident to someone else, whether it's, a bad fracture or whatever, what's the responsibility of an operator for me for that, that mental trauma that I might experience? I guess, is that even coming up yet, or is it something that's under the surface still?
I think in injury law generally, there's a lot of claims of that kind. People suing because they've suffered trauma from witnessing an accident. Might be motor vehicle, might be an industrial accident. Those sorts of things. We're seeing them a lot in the last few years, and there will be more because it's a burgeoning area of liability. I'm not sure if you can do much to protect yourself from a participant witnessing an accident and having mental injury as a result of that, and then suing you. But if they sue you, they still have to prove you being negligent in the conduct of the activity, and you were negligent that caused the injury to the principal person, the first person, to be able to show that due to your negligence, you've caused psychiatric injury to the other person. But they certainly can recover. That the legal principles say that if someone who witnesses a trauma of that kind will have rights.
Yeah, and another comment with that. So, for example, the waiver that I, or the medical form that I send out to participants before a program is, have you experienced any mental health issues in the past 2 years? And, space for reporting that. And second, following, if there was an incident during an activity or something, I'd always offer some sort of counselling afterwards. That would be a kind of standard practice. I'm sure everyone here would see that as a sort of standard practice following a critical incident.
Yeah, debriefing is important. But I mean, obviously, if they disclose they have pre-existing mental health issues, then you have to make an assessment about whether they are suitable for the activity and whether they're at risk, or other people at risk because you'll bring them along and they'll be participating in activities that might cause harm to others. But it's a really tough decision without clear information about their mental health condition and what it means for them. It's really hard, and would be hard to exclude them, I think.
That's right.
And the courts will take into account that if they do suffer a mental health injury as a result of witnessing an accident, that they were already predisposed to such things, but they still will be entitled to recover damages in most circumstances.
Ross, I think the biggest alarm bells sort of that's going off for me is your comment on online waivers, because we've come through this COVID world where we can't touch people and do all that sort of stuff. So we've gone into this dump of online content that people have got to read through and absorb. What's your advice when it comes to if there's no other way other than to deliver that online, what are some things that we've got to think about to really alleviate some of those challenges with people not reading, ticking and flicking and going, yep, I didn't understand any of that, but okay.
The problem I've seen is that other people book for a group, and if you've got a friend booking you on a trail ride and booking 4 people, then the argument is that the person who's injured didn't actually agree to the terms and conditions of the provision of services. There's no contract between them. That's the obvious one I've seen.
Yeah.
I think otherwise, if there's a proper disclaimer and warning and it's acknowledged by the participant, that should be okay. Yeah. And I think there are, you probably have systems where each participant has to read it and acknowledge, and that should be sufficient. Yeah.
Yeah, awesome. No, that's
but
great.
I can get back to you. I'll have a look at a few cases on that because there is a problem about that, and I might send you some bullet points about what I think the way to address it might be.
That'd be fun.
Yeah.
Nicole, did you just want to talk to your little comment in the chat?
Yeah, we have been doing a hybrid model, so we're doing online bookings but still having paper, the participant consent form in paper. So it's a little bit tricky, but yeah, doing the online booking, we do see that group booking thing happen, and
Yeah,
this
great.
person's booking for others. So we've kept the importance of that paper form, and even the relevance of, is this activity at a suitable level for the participant, so that we know that there's been some acknowledgement that yes, this is suitable.
Yeah.
In the trail ride space, you can book online, but then you turn up to saddle up, and they give you a clipboard with the form, and you have to read it again, and you have to sign it in front of, or you should be signing it in front of the operator or an administrator, and that you acknowledge the risks. And also they usually ask, what sort of experience do you have, so they can choose the right horse and saddle and things like that. People tend to fundamentally lie about their experience, but that's just a problem there. But
yeah, absolutely.
Nicole's from Riding for the Disabled, so she's nodding
okay.
her head very, very
Don't worry, I lie about my experience when I go trail riding. I say I have no experience, because I don't.
I want the calmest horse. I want the best.
I don't want to sort out the problems.
Yeah, no, absolutely. And Ross, I love your top things to think about. I don't know whether I can do justice to them, but just to reiterate, you talked about obviously the risk warnings, being very upfront, understand the skills of the participants, seeking to minimize the environment risks, being clear on how you're meeting rules and guidelines, because that's what's going to be referred to in a court of law potentially. Regularly review the conditions, take your actions, but make sure you're recording your thinking and the actions accordingly, so that you can justify those. And then of course, talking about waivers and acknowledgements of the risk. Can't be relied upon, but certainly need to be compiled by a legal authority that knows the currency of the laws and what's required. And yeah, as you said, the online waiver, just making sure that you've got that covered for the individual and not group bookings. And the final one is make sure you've got good liability insurance cover for all your activities. Did I summarize that well? Did I miss anything?
No, that's great. That's really good.
Okay.
Thank you. Just in regard to equipment, recording, the equipment you have, inspections you undertake of that equipment, how often it's reviewed, how often it's replaced, those sorts of things. They're pretty important in horse riding activities. I think in rock climbing and probably other activities. It's to show that you maintain a regime of surveillance and monitoring of your equipment and replacement, so that if some equipment fails, and it does, you've acted reasonably by turning it over within a period that's recommended by the code or an association or something like that. So that's important too.
Yeah, no, really good points.
I did say I was going to try and find some hiking cases for you, but there's a couple, but they're very, very old, and they don't apply the sort of more recent legal principles.
Right.
In both cases, I think they were cases where the school was found not liable, where some child was injured on a school hike. One sort of jumped over a river and twisted their ankle, and one was injured, and there was a dispute about whether the first aid was appropriate and how they were managing the injury. But generally, the courts were quite favourable to the schools in the sense that kids have to be given a certain level of autonomy and exposed to a certain level of risk to make decisions themselves in the outdoors, and the risk offered to these kids was proportionate to the activity and their experience, and so the school wasn't found liable.
This is a question without notice, and apologies if tell me if you don't want to answer it today, but one thing that I'm continually seeing with social media is, someone going, hey, I'm going to go out on a hike. How about you come with me? Or who wants to come with me? And they put it out to the public and potentially don't know the other participants, but that person has instigated that discussion. Now, my thought process, talking through some of the challenges of these cases, is if something goes wrong in that circumstance, is there a liability associated with that person that instigated that trip or that conversation around that trip?
I think potentially yes. I certainly haven't.
Mm.
I can't think of anything analogous to that. But yeah, if you're organising an activity, you might have assumed a responsibility. If you're more experienced than other people, or have considerable experience, and you want to put a hike together, yeah, there is a risk that you've got a responsibility there.
Great. Okay, thank you for that. Guys, we might wrap up this discussion, and I'll do a bit of an update on all things that people need to know about. But any last questions for Ross before we let this fountain of knowledge go before us?
Thank you.
I love your
Thank you.
I love all your backdrops.
Oh, thank you. Yes,
Makes you want to get outdoors.
We're outdoors
I
people, forced indoors, so we've got to have a compromise.
Yeah.
That's great.
All right.
Well, thank you for joining
It's lovely.
us, Ross.
Mary was here. I thought Mary was here. She was going to talk about insurance, actually.
Yeah, no,
are you here, Mary?
I can't see her there, but yeah, I'll certainly invite her onto the next one, and maybe cover that off in another session, because we've certainly had a great conversation here.
All right, good. Thank you.
you.
Nice
Thanks
meeting you
so
all.
much, Ross.
Thank you.
Okay, bye.
Bye. And now I'll just skip across to my other presentation, and we've covered that one, so that's good. Look, I won't spend too much time. I've just got the list here of need to knows, and the OEA awards have actually been extended. They were meant to close today, but you've now got until the 30th of June to submit for the Outdoor Education Awards. Don't forget the grant that's available for the overnight camps that the New South Wales government's come up with in response to our Term 4 shutdown last year. That is available till September, but as soon as you can get the money in the bank, that's a good thing. Membership structure that we've started will commence 1 July. So reminding everyone that if you are on the current model, it will continue until your membership expires, and then you'll roll over to the new structure. Again, I ask anyone that's concerned or has any thoughts around that to reach out to me, and I'm happy to have that conversation. Lots of new tools on the website, including list your business, list your event. So make sure you put all of your activities into that website, because we'll be certainly doing a lot more promotion of that site. Don't forget the Navi offers. Get in before the 30th of June, which I think is next Thursday, if my memory is correct. There's the e-health check, which is totally free, a great offer by Navi, where they go through your digital platforms and just give you a little bit of a health check on all things compliance and safety and so forth. And then they've got their 30-day program, which I have to say I've been doing, and it is amazing. It's actually really, really good. If you start today, you'll start day one, and it'll go through for 30 days. But there's little things that they send you every day, like I can't remember what today's was. Oh yes, it was changing your favicon. How do you change your favicon? Does everyone know what a favicon is? Gillen does. So on a website, if you go up to your tab and you look across all of your different tabs that I've opened, if it's anything like me, and I've got about 600 up there, but you can actually see a little icon in the little tab area, which identifies your website. So for us, we've got the little round circle off our logo. For others, it might be something different. So you can change your favicon. That was today's tip. So really good program that Navi is offering. The Connect and Shares, we've got Mark Laurenti from Office of Children's Guardian talking about the risk management tool on the 8th of July. And don't forget, we've got our colleagues across the ditch in New Zealand coming and joining us on the 15th of July. And there's also some other programming ones, which I'll mention as they come in. The ACT mentoring program is kicking off on the 6th of July, which is awesome. We've got some great mentees, some great mentors. The program is still open, so if there's a few last minute people that want to jump into that program, please let me know. And finally there we have the program has been released for the National Outdoor Education Conference. So for those that are members of Outdoors New South Wales ACT, you would have received that already. Everyone else will be receiving that today. And make sure you get your tickets because there's only 82 left. So if you want to come along to that event, certainly jump in and register. And the final reminder is around the draft plan of management and also the master plan for the Gardens of Stone. I'm reiterating this one because I'm continually having conversations with different people around this place, and we need to make sure that we have all of our opinions and our opportunities and everything that we could perceive happens in this area documented and thrown through this process so we are heard. So that's pretty much it for today, guys. And look at that, 4 minutes to spare. So if there is anything that anyone wants to speak about, certainly make sure you just jump in and start the conversation. Other than that, I will close the recording